The lawyer paid to protect her stood in front of a microphone this week, and he did not defend her the way anyone expected. He did not call her a victim. He did the opposite. In one sentence, Elizabeth Sider's own attorney took away the one label that could have saved her. Most people miss this, and most channels are not going to cover it because it did not come from a courtroom. It did not come from a filing. It came from a moment during a press update in Vinton County this week, and it lasted maybe 15 seconds. But if you were listening carefully, it was the loudest 15 seconds of the entire case so far. Let me set the scene. For weeks, one storyline has been building around Elizabeth Siders. She was married at 15 years old with judicial consent to a man much older than her. She had her first child at 18. She lost twins at 24 weeks of pregnancy. She lived for her entire adult life inside a household that is now the subject of a national criminal case. And because of all of that, many observers, including at one point her own attorney, suggested she might be less a co-defendant and more a survivor, that she might have been living under what a defense attorney would call coercive control. That framing has now been quietly but publicly dropped. At a press update this week, Prosecutor William Archer confirmed something that most viewers have not yet processed. He said that Elizabeth's own defense counsel, the same attorney, J. Thomas Stolley, is now telling the state that she is not a victim. Not a victim. Those are the words the prosecutor said the defense had used. In the same week, the defense filed for an insanity evaluation. So let me walk you through what that means, because it is one of the strangest pivots I have ever seen in a case this size. Earlier in the summer, when the household was first raided and charges were filed, the softer public messaging from Elizabeth's side leaned toward a duress defense. That is a real legal path. Duress means a person committed a crime because another person forced them to. In domestic abuse cases, this is sometimes called coercive control, a long, slow pattern of psychological pressure, isolation, financial control, and physical intimidation that removes a person's ability to say no. If Elizabeth had gone that route, her defense would have said, in essence, yes, these things happened, but they happened because she had no real choice. That door is now closed. This week, her attorney pivoted, not partially, fully. The new defense is insanity. Not that she was forced, not that she was controlled, that she, on her own, may not have understood the wrongfulness of her conduct at the time. Two completely different survival strategies, from the same lawyer, in the same case, in the same summer. You cannot legally run both of those defenses at the same time. Here is why. Duress says, I knew it was wrong, but I was forced. Insanity says, I did not know it was wrong at all. One requires her to have been a rational person acting under pressure. The other requires her to have been an irrational person acting on her own. You have to pick. Her lawyer picked. Now, the question every viewer at home should be asking is, why? Because on the surface, the coercive control defense sounds easier to sell. It sounds sympathetic. It sounds human. It fits the biography. Married at 15, half a lifetime inside one household. There is a public that would understand that story. There is a jury pool that would understand that story. Jurors could nod along with it. Older jurors, in particular, the ones most likely to sit on a case like this in a small Ohio county, would find that narrative familiar. Insanity is much harder to sell. Insanity requires expert psychiatric evidence. It requires the defense to prove, on the record, that the defendant did not know right from wrong. It succeeds, as we said in an earlier report, in less than 1% of felony cases. It carries a much higher bar. So why walk away from the easier path and choose the harder one? There are a few possible answers, and I want to give you all of them so you can decide. The first answer is legal. Sometimes an attorney learns something in discovery, meaning from the evidence the state has collected that makes a duress defense impossible. If there is evidence that Elizabeth was, at times, an active participant rather than a passive victim, then duress collapses. In that scenario, her lawyer had to move. Insanity became the only door left that could still lead to something other than a straight conviction. The second answer is family-facing. Duress requires you to name your abuser, in court, on the record, under oath. It requires you to say, out loud, the name of the person who forced you. In this case, that person would almost certainly be her husband, Gary Sider Sr. If Elizabeth had gone with duress, she would have had to publicly and legally testify against him. Insanity does not require that. Insanity lets her defense stay quiet about her husband. And in a case where the family unit is under investigation together, that quiet may be its own kind of strategy. The third answer is the hardest one, and it is the one I want us all to sit with for a moment. The third answer is that maybe the truth is not simple. Maybe Elizabeth was a survivor, and also, over time, became something else. Maybe both things can be true. That is not a comfortable idea. But real cases, real households, real families, they do not always fit into one clean word. A person can be groomed into a system as a teenager, and 20 years later, be an operator of that same system. Both can be real at once. And a lawyer, looking at that reality, may have decided that the cleaner defense was to argue that her mind, over all those years, simply broke. Now, her own family, some of her relatives, have publicly said she was indoctrinated. That word has been used. It has appeared in interviews and community statements over the past several weeks. And that framing lines up with the duress argument that her lawyer originally seemed to be building. But her lawyer, this week, is not saying indoctrinated. He is saying impaired. And those two words go in very different directions in a courtroom. Indoctrinated is a story about what someone did to her. Impaired is a story about what happened inside her. Watch which word wins, because whichever framing the court accepts is going to shape the rest of this case. If the court accepts impaired, Elizabeth's outcome may look like a psychiatric commitment, not a prison sentence. If the court accepts indoctrinated, we are heading toward a very different kind of trial, one where her husband becomes not just a co-defendant, but effectively her captor. And here is where the moment this week gets even sharper, because Prosecutor Archer did not just repeat what the defense said, he made a point of it, publicly, on camera. He said essentially that even her own lawyer no longer considers her a victim. That is a prosecutor doing something very specific. He is drawing a line. He is telling the jury pool, before a jury is even seated, that the defense has already backed away from the sympathetic version of Elizabeth's siders. That is a powerful thing to say out loud, and it was not an accident. And her lawyer, the very same week, did not push back. He filed the insanity motion. He did not correct the prosecutor. He did not restate the coercive control framing. He let it stand. Sometimes in a case, the loudest sound is not what someone says. It is what someone chooses not to say. Let us pull back for a moment. For the audience trying to follow this from the outside, here is the honest picture. Elizabeth Siders is not being defended as a woman who was trapped. She is being defended as a woman whose mind may not have been intact. That is the version her lawyer has chosen. That is the version the court will now weigh. And that is the version the 16 children, some of them old enough to eventually testify, will one day hear. I want to speak directly to the older viewers watching this right now, because you have lived long enough to know that the words a lawyer chooses in the first weeks of a case are almost never accidents. Lawyers are careful people. They pick their language the same way a carpenter picks the right tool. When Elizabeth's lawyer chose impaired over indoctrinated, he was picking the door he wanted the case to walk through. And you already know that once a defense picks its door, it very rarely walks back to the other one. There is one more piece I want to add before we close, because it is the piece that most of the coverage this week left on the floor. When a defense lawyer switches survival strategies mid-case, he does not do it alone. He does it in consultation with his client, which means somewhere in the last 30 days, Elizabeth Siders herself sat down with J. Thomas Stolley and had a very serious conversation. And she agreed in that conversation to walk away from the victim framing. Think about that for a moment, because that is her voice too, even if her lawyer is the one holding the microphone. She could have insisted on the coercive control defense. She could have refused to go the insanity route. She could have told him in that meeting that she wanted to be defended as a survivor and not as a woman whose mind may not have been intact. She did not do that. Or if she tried to do that, her lawyer, in his professional judgment, moved past it anyway. Either version tells you something. And that is the strange, uncomfortable thing about the American legal system. A defendant is entitled to the best possible defense, but a defendant is also part of that defense. She helps choose it. She lives with it. She has to sit in the courtroom every day of trial next to the story her own lawyer is telling about her. If that story is one where she is not a victim, but a woman whose mind may have failed her, she has to nod along with it every day in front of the jury and in front of the community she grew up in. That is a very hard thing to do, even for someone who has done difficult things. I want to speak again directly to the older viewers watching this, because you have seen this pattern in family cases before. You have watched people give up the story you thought they would tell, in exchange for the story their lawyer thought they should tell. And you have watched, decades later, some of those people quietly say that they wish they had insisted on the first version. Legal choices are permanent in a way that a lot of viewers do not fully understand until they have lived through one. Once you pick a defense, the record locks around it. Every future appeal, every future parole hearing, every future retelling of your case has to work inside the story your lawyer wrote in these first weeks. Elizabeth Siders is inside those first weeks right now. So whatever is being decided in her defense meetings this month, those decisions are going to follow her for the rest of her life. That is why this week mattered. That is why the word victim being set down matters. Not because the label itself was ever the truth, but because whichever label the defense picks in these first weeks is the label that gets carved into the record. And that record does not soften with time. It hardens. Whatever the truth turns out to be, one thing has already changed this week. The label victim has been quietly set down. It may still return. Lawyers change strategy. Defenses shift. But right now, in this window, the person paid to protect her has moved past it. And that is the story tonight. A young marriage, a long silence. A courtroom full of paper, 16 children in state care, and a lawyer in front of a microphone choosing which version of his own client he was going to defend. He chose. And now the case moves on that choice. We will stay on this. If the framing shifts back, you will hear it here first. If the insanity evaluation is granted or denied, you will hear that here first. But tonight, we sit with what her own lawyer decided to say out loud this week, and what he decided not to say. That is where we leave it.